I'm so excited that you guys are joining us today. I want to apologize in advance. I lost my voice about 10 days ago and it's still coming back. So I'm going to do my best to speak clearly and not cough too much. For those of you who don't know me, Michelle Dexter, attorney at law. I've been here at Keystone Law Firm for 8 years. We specialize in estate planning, probate work, guardianship, conservatorship, trust administration, those types of things. I've been an attorney for over 20 years now, but I've really enjoyed working here at Keystone, and I love the help that we're able to provide to our clients and their families. So we're excited to be able to bring some of these webinars and specialized training and education for the community so that they can understand what things to be looking for and learn about whether or not they could utilize some of these pieces of information in their own estate plan, okay? So today we're going to be talking about special needs planning for children and grandchildren, all right? What we find is that a lot of times people don't plan, and then what they think they're leaving as a gift to their beneficiaries ends up being a little bit more of a burden. So we want to make sure that we are addressing those things appropriately, and that we are just setting everybody up for success, and that your assets are kind of being utilized in the way that you intended them, okay? So when we're talking about special needs, generally what we're talking about is individuals who require some specialized support and services that could be entitled to government benefits to help pay for those things. Okay, we've got some beneficiaries that are born with certain conditions, whether that's an autism or Down syndrome, cerebral palsy, intellectual disabilities, and many other disabilities that can create issues with them that can cause them to need extensive medical care, those types of things. Other times, some people acquire these disabilities during their lifetime. That can be in the form of a stroke or dementia, schizophrenia, blindness, COPD, PTSD. You know, the list really kind of goes on and on in terms of what those disabilities can be. Disability doesn't always need special needs though, okay? People who have dyslexia or ADHD aren't necessarily categorized as special needs. They aren't necessarily going to qualify for government benefits because of those disabilities. We're looking specifically for people who are eligible for government benefits that help provide their support. That support can be their living expenses, their medical insurance, their food, therapies, you know, different types of counseling, those types of things that are in addition to what they normally are able to provide for themselves. And a lot of times these things can be really critical to providing them with a decent quality of life. When we're looking at government benefits, there can be, I categorize them kind of in two different types. There's the disability-based benefit. You've got a disability that qualifies you because it limits or prohibits your ability to work. And as a result, you might be entitled to, say, Social Security disability income, okay? SSDI is sometimes what they call that. That benefit is just based off of you having a disability and you having some prior work history where you've paid into the program, okay? Those people typically receive a monthly payment. They're pretty liberal in what they can do with those payments to pay for those, but they can't have full-time future employment. The future employment can impact how much they're able to receive from the SSDI. So the disability base is just really based off of the disability. Where we are concerned is more of what we call the means-based benefits. The means-based benefits means that the government is looking at what means do the individuals have to pay for these things themselves, okay? It can be in the form of income, it can be in the form of assets. A lot of times when we look at Arizona's All-Tech system, which is this Medicaid program for people that are over the age of 65, they have to qualify for those programs based off of their age, based off of their US citizenship. They obviously have to have a medical qualification. And then they're limited in how much income they can have, and they're limited in how much they can have in assets. Right now, that asset limit is $2,000, which is not very much. So you can imagine that almost any kind of inheritance from somebody could disqualify from that. Once they are qualified for those benefits, they are required to requalify, and the government will do audits on their bank accounts and take a look at that information. So it is important that they're staying within the rules of those government benefits and the qualification for that. Those types of benefits can vary from their housing to food, health insurance, making modifications to their house, long-term care, in-home care, vocational skills to improve their quality of life. And a lot of times, a lot of these people need those therapies in order to maintain their ability to walk or to have a decent quality of life. And so losing the benefits that pay for those additional health-related services can be really, really important. And so it can take a really long time to get on them, and losing them can be really kind of detrimental to people. So how it can go wrong, right? If your estate plan or trust does not address a special needs beneficiary, and that person is set to receive an inheritance, that person's not able to just say, I don't want the inheritance because I need to keep my benefits, right? They're not, we call it disclaiming their interest in it. They're not allowed to disclaim it, because from the government's standpoint, if you have money available to you to pay for your own care, you should be paying for your own care, okay? And so the government's not going to let the beneficiary say, no, I don't want the inheritance, just pass by me so I can keep my government benefits. So the beneficiary is going to be required to receive their inheritance. Sometimes if it's not too big of an inheritance, sometimes there's some different ways that we can strategize with it and try to minimize the impact of it. But the reality is that we can't just forego that inheritance. So the beneficiary is going to receive their inheritance. As a result, they're going to be disqualified from their benefits, okay? And then they're going to have to spend down those benefits, or they're going to have to spend down the inheritance so that they can get back to a point of where they qualify again, okay? And so that qualification period, I had one client that told me it took her brother 3 years to get qualified for the benefits. So she was really hesitant when her parents had left him money that was going to disqualify him, because she didn't want to have to go back through that qualification process. And I don't really blame her. A lot of times what they inherit isn't necessarily so life-changing that they're never going to need benefits again in the future, right? So we want to make sure that we're kind of addressing it and taking care of what those things are, and making sure that we're recognizing what the needs are of our beneficiaries, okay? Even if they spend it down as part of the qualification process, especially for the Medicaid program and Altex, they will look back over your last 5 years and look at how you've spent the money, right? So you're prohibited from giving away the money. If you can't go out and just gamble it away. There's certain things that you can't do with the money to try to get back within the required requirements to qualify for the benefits. And so, if you spend it incorrectly and the government doesn't like the way that it was spent, you can still be penalized and be without the benefits, and now without the money, without the inheritance for a period of time. And so it's really kind of a delicate balance, and something that we just really want to try to avoid if we can, right? And so there's a couple of different ways that we can provide some special needs planning for people, okay? I've got them kind of in 3 categories, and I want to go through the 3 different categories. The first category is what I call our backup language, okay? We aren't directly giving to a beneficiary that has special needs. It isn't really our intention for them to get something. So let's say that you have a grandchild, but you're leaving everything to your children. Your grandchild's got some special needs, but you're leaving it to your child, right? And the intention is that your child is going to receive the inheritance, and then they're going to take care of what needs to happen for your grandchild, right? I might put the backup special needs language in there just in case for some reason that grandchild ends up being a beneficiary. Those of you who work with me know I work in worst case scenarios. And so that is just kind of the world that I live in. And so I always want to make sure that we aren't just ignoring the fact that there is somebody downstream, so to speak, that could have special needs and could need a little bit extra protection in that regard. And so we aren't saying that the child is receiving a special needs trust, because the child, him or herself, doesn't need that level of care. But if it got to the grandchild, we've got that backup language in there, okay? So that's just kind of a backup situation that we put in when we're not giving to a beneficiary who has special needs, but there's somebody down the family line that could potentially receive it. And if they did, it could jeopardize some benefits, okay? The next level is what I call, we include the language, right? So we are giving to somebody that does have special needs, right? Maybe we are not sure that they're going to be getting benefits in the future. Maybe we're not sure, you know, a lot of times I've got a couple of great nephews right now that are on the autism spectrum, and they are very young. They're both under the age of 4. I don't know how high functioning they're going to be when they get older, right? And so there's the possibility that they could qualify for benefits, but I don't know yet, right? And so I can include language in there that says if they're receiving benefits at the time that they're a beneficiary, it's going to be handled as a special needs trust for them, okay? And so basically, when we are creating a trust especially, we can say beneficiaries are going to get their share outright. Beneficiaries are going to get their share in what we call a protected beneficiary subtrust, or beneficiaries can get it in what we call this special needs trust. And the special needs trust has the language that the government benefits are looking for to make sure that it qualifies as a special needs trust. Putting it in just a typical trust or beneficiary protected subtrust is not going to have the language that we need and the directions to the trustee to make sure that that is taken care of appropriately and that they are still qualified for those benefits. When we've got special needs trusts, the beneficiary is not their own trustee. The trustee is somewhat limited in what they can use those funds for. Funds are not intended to replace the benefits that the government is providing. It's intended to improve the quality of life, excuse me, and provide for things in addition to. And so we call it not supplanting, but supplementing. And so we want to make sure that we have the correct language in there in order for the subtrust to qualify as a special needs trust, okay? The third type of special needs trust that we can have is what we call a standalone trust, okay? And a standalone trust can be used in a couple of different ways, all right? The first way is what we call a first-party special needs trust, okay? This is typically a very specialized, often court-approved type of trust, okay? We use this type of first-party special needs trust in situations where we have a beneficiary who is receiving benefits, who is receiving inheritance. We also use them when somebody is receiving, say, a medical lawsuit settlement or some other insurance payout, right? They're going to receive those funds, but everybody knows that they qualify for benefits without these funds and that they're going to need ongoing medical care for the duration of their life, whether it's because of a special need or some kind of accident that they were in or you know, some kind of disability that they have, okay? Those first party special needs trusts allow that person as the beneficiary to go to court and say, I would like to receive this inheritance or these settlement proceeds in the form of a special needs trust. And by doing so, they agree that anything that's left in that special needs trust at the time that they pass is going to be used to repay the government. Okay, so a lot of times our clients that learn that there's a trust in place and somebody didn't provide for a special needs beneficiary, they're not happy to learn that these funds are going to go back to the government if the beneficiary doesn't use them all. They would much rather them go back to the other family members than go back to the government. These first party special needs trusts are pursuant to a federal code, we refer to it as a D4A trust. Okay. And so we get it approved by the court. We get it approved by the Medicaid facilities, right? I used it in a matter where a daughter lost both of her parents. She had been born with developmental issues. Her brain wasn't fully developed at the time she was born. So she's never been self-sustaining, self-supporting. She's always needed full-time care. And unfortunately, her parents didn't set up anything for her. Mom died one year, dad died the next year. And so she was set to inherit. They had done a good job of providing money for her, but they didn't set up who she was going to live with, who was going to take care of some of those things. And so we ended up going to court and getting a D4A trust put into place for her so that she can have the benefits that she needs to pay for her ongoing care, and she can have this money from her parents as kind of an additional quality of life type of thing for her during her lifetime. When she's done using the assets, anything that's left will first go and reimburse Medicare for what they've paid out, Medicaid for what they've paid out for her. And then anything left over, if there is anything left over, will go out to the other beneficiaries that would normally inherit. I had a lady who had sued the hospital for a medical malpractice matter. And part of her medical settlement was that those funds had to be placed into a D4A trust. Okay. Now, interestingly, she could qualify for benefits. She doesn't want benefits. What she'd really like is access to this money, right? But she's not going to have access to the money because it's a court-approved trust that's in place to protect, in part, not only her, but also protect the government. And so as much as she would like the freedom of having that money, the reality is that she's never going to have direct control over it because it's in this D4A trust, okay? We also used it in a case where a child was in a product liability settlement. The product had negatively impacted his heart, and so he was going to need ongoing health care. And so the court and part of the settlement required that those funds again go into this type of first party D4A trust, okay? And so that's kind of, it's nice that there's an option there that's available for people who are under 65 who are disabled, but it's not a great option because the money doesn't get to continue going on through the family. It just is really limited to that one person, okay? The other option is what we call a third-party special needs trust, okay? And this is really the type of thing that a lot of families who have disabled special needs family members want to consider, okay? This allows a parent or a grandparent to create a third-party special needs trust for the benefit of a special needs beneficiary. And anybody can contribute to that trust, right? The parents can, the grandparents can, the aunts and uncles can, whoever wants to can contribute to this third-party special needs trust. And the creator of the trust gets to direct where those funds go if there's still money left over at the time the beneficiary is done using the money, okay? And so this is a really significant difference between the first party trust and the third party trust, because it allows for those funds to continue to go on to other beneficiaries, which is really good. So going back to my great nephews who are autistic, his parents created a separate standalone special needs trust for them. Okay. Their trust currently says at the time that they pass, a certain interest will go into that special needs trust. But now grandma and grandpa can also name that special needs trust. They can say, hey, first to my child, and if my child's not there, then a percentage to the special needs trust. So we don't accidentally have money coming out to that grandchild directly and jeopardizing any kind of benefits that he may be entitled to, okay? I had a matter recently where grandpa had a will. He had special needs language within the will for his grandson. It was kind of out of state. The grandson lived here in the state of Arizona, which is how it ended up with me. The way that his estate was laid out, nothing really had to go through the will. Okay, and so everything went out directly to beneficiaries. And so his son felt like that defeated the purpose for this grandchild. And so the son set up a special needs trust. It was actually for his nephew, and put some money into it so that it was kind of effectuating what the will would have done had the funds gone through the probate court and through the will at that point in time. Okay. Now, the downside to that scenario is that when things don't pass through probate directly to the beneficiary, and I see this sometimes where people are like, I just want to leave it all to my daughter, Michelle, and she's going to distribute it out to everybody else. And I trust her to just, take care of that. And that's great. I'm not questioning her ability or her willingness to do that. But what you have to realize is that depending on how much money we're talking about, Michelle is the one who inherits it, right? When she makes a distribution to, say, Andrea, that is a gift now from Michelle to Andrea. That's not an inheritance from mom to Andrea. That's a gift from Michelle to Andrea. And so depending on how much we're talking about, that could trigger a gift tax return requirement. It could trigger some other issues. And so we want to be careful about some of those types of things. So while in his case, he was able to set up that special needs trust, that standalone special needs trust for his nephew, the transfer of money in there has to be strategically placed so that he's not running into issues with the tax authorities. Okay. Now, you may hear the term special needs versus supplemental needs when it comes to some of these trusts. There's been a shift, I would say, in the last probably 2 years, kind of moving away from the term special needs and moving more to the term supplemental needs. The truth is these are pretty much the same type of document, but what we're finding is that the term special needs trust is coming with an implication that there's going to be the reimbursement to the government agency that's paying out benefits. And the supplemental needs trust doesn't have that same implication. And so people don't expect to see some kind of reimbursement from there. And so a lot of times when we're creating those third-party trusts, we're using the term supplemental needs trust instead of special needs trust. And I just wanted to make sure that everybody was aware that they really are doing a lot of the same things. And if you see the term supplemental needs trust instead of special needs trust, it's probably just because we're trying to avoid that reimbursement to the government agency. Okay. Let's see. We're going to get to the end here, and then I'm going to have time for questions if anybody has any. So the sum of really all of this information is that planning is key. Today we want to make sure that we're planning ahead for those who are receiving benefits. Consider the backup language if there's a family history of disabilities. If you have a family history of dementia and you worry that maybe your kids will also end up with dementia, you might want to put in that backup language. You don't necessarily have to have evidence today of it, but some of these disabilities can be inherited. And so we just want to be more cognizant of what are the potential conditions that our kids could be going through. We had a lady recently who had a very, very severe stroke and is now completely incapacitated. And we had to go to court and get a guardian and conservator in place for her because she didn't have any paperwork in place. And so, if she stands to inherit anything from anybody, there's going to be a moment in time in probably the next couple of years where she's going to qualify for benefits because she will have spent down most of her assets to pay for her health care now. And so we just want to make sure that we're considering some of these things. In the future, make sure that you're reviewing and updating your estate plan regularly. Consider if any of your beneficiaries have or are likely to have a disability in the future. We here at Keystone, those of you who are trust care clients, we like you to come in every year. We'll ask you, how are the kids doing? How are the grandkids doing? Are there any changes with any of them? Because those types of things are the things that trigger us to say, do we need to consider backup language? Do we need to consider some kind of special needs language? If you come to us and say, my son has a significant health problem and I'm concerned because he hasn't been able to work and his resources are getting low, that to me says, wow, do we need to be considering that he might qualify for some kind of government benefits in the future? Is this something that we should be having a further conversation on? Do we need to, follow up more next year? Let's look more closely at, what needs to be done type of thing, okay? Your language can provide for termination of the special needs trust if the beneficiary does not need that protection. So just know that putting the special needs language in there when you're unsure, it can have a kind of a get me out provision if you need to, right? And so sometimes, when the kids are young and we're not sure if they're going to qualify for benefits in the future and what their needs are going to be in the future, right? I can say, look, if they're self-sufficient for, by working a full-time job and paying their own expenses for the period of 3 years or for a period of a certain amount of time, right? Then you can say, okay, based off of that, the trustee is able to, if they feel it's in the beneficiary's best interest, to terminate the special needs portion of the trust at that point in time. But that allows your trustee, and those are the people that you have entrusted to make the right decisions for your estate plan, to make that decision versus, just some automatic cutoff. Let's make sure that somebody's looking at the totality of the situation, okay? What we need to know is that your trustee can't add special needs language to your estate plan in the future, right? So it's important to kind of have those awkward conversations with your family and understand how certain benefits are impacting them. A lot of times I talk to families who the kids don't talk to the parents about their finances, and the parents don't always talk to the kids about their finances or those types of things. But if you can look at it from the need to make a smart legal decision with your paperwork, hopefully that conversation is less about feeling like you're being nosy and more about feeling like you want to do what's in the best interest of your beneficiaries and make sure that we are setting them up properly, okay? One thing I want everyone to keep in mind is that planning for special needs in your estate plan is not the same and is not going to address the potential need for a guardian when a disabled individual turns 18. We do a lot of graduating high school senior events to make sure that they're getting their healthcare power of attorney and HIPAA authorization in place. But if you have a child who is 17 and a half, who is disabled and is going to need a guardian, you can actually apply for the guardianship at 17 and a half so that that is in place at the age of 18 and there is no gap in coverage. A lot of times those disabilities are very medically heavy, and so we don't want to have a couple of months where we're waiting for a court order and in the meantime the doctors won't talk to you or you can't make doctor's appointments or you're running into some issues like that. So we do want to make sure that people are aware that that special needs trust does not address the guardianship and the making of medical decisions for a disabled individual. Okay, so just something to keep in mind. For people that get their disability later in life, if they can have a healthcare power of attorney, if they can have a HIPAA authorization in place, that will help us to avoid a guardianship for them in the future. But we want to make sure that we're kind of looking at these things from all angles with those beneficiaries, because it is really important that we do what we can to kind of keep them out of trouble and keep them out of court to the extent that we can, right? So, the best way to make sure that your money is going to be used in the beneficiary's best interest and not just get sucked into paying for things that government benefits might pay for otherwise is to make sure that you've got the appropriate special needs language in there, okay? So that just about brings me to the end of my information. I'm happy to answer questions for those of you who might have any questions with regards to special needs. Keep in mind this is being recorded and will be available on our YouTube channel later. So if you do have a question, we encourage you to keep it somewhat generic and not give away any personal information in that question so that you're not being blasted anywhere with regards to that. But we certainly appreciate you guys attending these webinars. We're trying to make sure that we get some educational information out to not only our clients, but to the community. We've got some more webinars that will be coming up. If you would like to talk to Francisco, who's kind of the other part of the Keystone law firm here to discuss that. We've put in the chat a calendar link that you could go ahead and throw some time on his calendar at no charge to talk to him a little bit more. One question from Jeff: how much should a trust be funded with to start? You know, here in Arizona, we are a little different from a lot of other states. And so the process in Arizona when somebody becomes incapacitated or passes away can be a little bit more burdensome than in other states. And so typically it's not a matter of having a minimum amount in a trust. What I get more concerned about is if something happened to you, would the people, the loved ones in your lives need to access your money to pay for your expenses, right? A lot of times when I do the graduating high school senior events, the parents are like, this is great, I've got the healthcare documents, but do I need financial power of attorneys? And I say, well, you know, if your kid was in a car accident or in a coma, would you be using his or her money to pay for the medical expenses, or would you be using your own money to pay for the medical expenses? And, you know, for most of our teenagers, they don't have enough that is going to help us a whole lot in paying for major medical things. So accessing their money is less of a concern. But if your family is going to need to access your money to help pay for your expenses, we want to make sure that we've got the right documentation in place. And a trust is a great way to do that, because the trust gives less discretion to the banks. And I've done another webinar on wills versus trusts that is available in our YouTube collection that you might want to watch, Jeff. So it's not so much that there's a minimum, but definitely to the extent, you know, if you own real property, if you have a bank account with, you know, some decent money in there, if you've got some personal responsibilities here in Arizona, that's the time to start considering getting a trust in place and getting your estate plan in place, which is a whole set of documents. It's a whole package to make sure that we're covering you from avoiding a guardianship, avoiding a conservatorship, avoiding probate, and making it as easy on your family in those cases of emergency to make sure that they're able to step in and take care of the things that need to be taken care of for you without too much problem. But great question. Anybody else with any questions? I'm more than happy to answer them. You're welcome, Jeff. Thank you. Lisa, I don't know if you want to write a question or if you see if I can unmute. I can't unmute you, but you might be able to unmute yourself.
I think I just did.
Oh, there you are. Yes.
Okay. I'm going through divorce. We have an adult son who does get SSDI, and I'm looking for suggestions on how to structure requesting us both to contribute to a trust for our future care of our son.
Sure. So I used to do family law, so I can relate a little bit on the family law end of things. Ideally, if you could create a standalone trust, right, he would be able to contribute to that. Where I'm going to foresee some pushback is the potential for him to feel like you're now controlling it versus him controlling it. And hopefully your guys' divorce is a little bit more amicable than that, especially given the needs of your son. But that would be my suggestion, is if you guys could come to an agreement in terms of that. And you could potentially even say within that trust that if you can't act as trustee, that he can act as trustee, or maybe you would be willing to name both of you guys as co-trustees on it, depending on how well the two of you are getting along. But definitely I would probably be looking at that standalone special needs, third-party special needs trust, where he could contribute money, you could contribute money, and to the extent that you both need to, that money could potentially not be contributed in there until you're done using the money yourself. And so it could just be part of your trust to say, when I'm done using my money, all of my estate's going to go into this special needs trust for him. And your ex-husband could do the same thing to say, when he's done with his money, the money's going to go into this sub-trust. And, you know, just knowing that it's taken care of that way versus having a couple of different special needs trusts for him, which can get complicated and can be burdensome for the people that have to manage it. But that would be my recommendation, is if you guys can both get on the same page with that, is to have that third party special needs trust that can be the beneficiary, because then not only can the two of you add to it, but grandparents can add to it, or anybody else if they're so inclined.
If we both can add to it, is it also the same scenario that my ex hasn't spoken to him in 2 years? So that gives you an indication. Is it also this situation where either of us could withdraw money from that trust?
Well, it depends on how you set that trust up, right? If you created it, you would be the grantor, the trust maker. I refer to the trust maker as the rule maker. And you can say who can be the trustees or the people who are administering the trust, right? And so initially you would probably be the trustee of the trust. If he doesn't have much of a relationship with your son, it's probably unlikely that you would name him as a trustee of the trust unless something changed. But perhaps the two of you could find people that you would both agree upon to be the trustee if you couldn't be the trustee. And so that might be the direction that I might kind of work in with that. And like I said, he doesn't really have to contribute anything until he's done with his assets if he wants. So to the extent that he's not happy about you managing the money while he's alive, he doesn't have to put anything in there, but his estate plan can say, when I'm gone, my money is going to go into this special needs trust because I know it'll be protected for my son. And I know that there's people lined up to take care of it. And then he doesn't have to do his own separate special needs documents for him.
How much does it cost in general to set up a special needs third-party trust?
A third-party special needs trust is generally, I want to say, around $3,500. Yeah, because it's a little bit more specialized. There's some things that we go into with regards to what the goals are for the parent or the grandparent for the kid in terms of some of the expenditures and things like that, as well as kind of setting up a longer term plan for successor trustees, right? Because obviously the goal is that he's going to outlive you, and so we need to set up a series of trustees or a provision that allows somebody else to step in and be trustee, so we don't end up having to go back to court to get a trustee named.
Okay, thank you so much.
You're welcome. Thank you for joining us. And thank you, Emmeline. I really appreciate the kind words. So anyone else with questions? Happy to answer them. I know we finished a bit early, but special needs planning is a little bit of a niche. And so we just want to make sure that we were focusing specifically on special needs and not getting too far off into too many other different directions with it. All right. Alexis, do you have information for everybody with regards to what our next webinar is coming up?
Yeah, of course. Thanks, Michelle. Great webinar. Thank you all for coming. And yeah, Francisco is going to be hosting a webinar on October 15th, which is more of a specialized for rental properties into a family limited partnership. So it's basically how to set up a management entity for X protection and how to qualify as an active investor to unlock powerful tax deduction. So that's basically what we're going to be looking at on October 15th. If that's something you guys would be interested in learning a little bit more about, I'm going to add the webinar link to the chat right now for that webinar. And we will also be sending out some more invites over the next couple of weeks for other webinars hosted late in October. We do have another one in, let me just pull up here the date real quick. Which is more of a workshop to make your own will and trust decisions. So we're going to be going over our usual client questionnaire that we have for our existing clients as to who to name as trustee, grantor, as Michelle has mentioned as well, beneficiaries, power of attorney, all that fun stuff, right? So that's going to be on October 24th. And that one would not be recorded because we're going to actually have a pretty strategic session with Francisco that day. So if you want to learn more about that, I'm going to drop in the chat here the link for that date. So that's October 24th. And that one is also hosted by Francisco. So that one is a really good one if you guys have not set up your own trust yet. It's a very good starting point for you to understand what you need to know. And yeah, so that's what's going on for the rest of October. And I also dropped in the chat the calendar link for Francisco if anybody wants to take some 15-20 minutes of his time and chat about, this subject, previous subjects, or upcoming subjects. Francisco's open to that as well. But that is it from my side. Michelle, do you have anything else?
Thanks, Alexis. Yeah, that one on October 24th, especially for those of you who haven't created your estate plan yet, it can feel really intimidating to have to make the decisions. Attend that. It will really help you in terms of finding a solution, knowing that we're not trying to plan for the next 20 years, we're trying to plan for the next 2 to 5 years. And Francisco is really good at kind of guiding you through picking some of those people. I will just mention that also at the end of the month, I'm due at the end of October, excuse me, I am doing a horror stories in probate for a little Halloween special. I personally enjoy the examples of how things can go wrong. And so if you would like to be entertained by some of those stories, please join me. As people a lot of times just think, oh, it's going to be super simple. And sometimes it's those simple ones that turn into real nightmares. And so, if you give me a request for something, sometimes I can say back to you, this is why I don't recommend that. And this is just going to be kind of a summary of all those situations, so that you can consider the things that you should definitely be steering clear of. So if you're interested, Alexis just put that link in the calendar or in the chat message as well, and you can get signed up for that one as well. So we really appreciate you all attending these. As I mentioned at the top of the presentation, it's really important to us to educate the community in the benefits of having estate plans, the different things we can do with estate plans, and some of the different things. We've got Carmi doing some financial webinars and Francisco doing some specialized webinars as well. So we appreciate you guys attending. Please reach out to us if you have any questions. And if there aren't any additional questions for today, we'll wrap it up and let you have back the last 15 minutes of the hour. Thanks so much for attending. It was a pleasure talking to you guys and sharing our knowledge with you today. Have a great day.